a sort of effect approach, then in theory, there would be always a country where you can bring your case. And we might for sure argue that it's not sufficient and the instruments, both procedurally and substantively, are not adequate, but there would be one place that has clear jurisdiction, which would be, I think, more clear. But again, I don't see even your facial expression, so I don't know if I disgusted you with the answer.
He's smiling.
He's smiling, okay.
Your question for Katherine.
Yes, and I'm not advocating this, but it just surprised me when you were thinking of ways to reconcile state and federal, and immediately preemption comes to mind. Now, politically, I want to ask you to predict that. Obviously, what's happened with securities laws is Congress has moved to preempt. I don't know, unless you want to speculate, whether enforcement actions, states picking up the Morrison will get the political push, because I'm not sure that it's the same sort of venture capital in the United States that are going to be the defendants in those cases and pushing for them. But the question occurred to me is there some sort of implied preemption where the court might sit there and say, having now interpreted the statute using the presumption to not cover, and for the reasons you argue, we will then also interpret Congress's intent to preempt the field and prevent state action.
Well, I guess it just sort of seems to me somewhat unlikely. I'm not an expert in the law the law of preemption, but I guess it seems to me that there'd be such an absence of congressional intent to do so. I mean, just congressional inaction, which is what we have. We'd be really inferring the intent to preempt from Congress doing nothing, or affirmatively deciding itself not to regulate in this area. That seems sort of improbable as a theory of preemption, and maybe it's a direction in which courts could go, but I think in terms of existing law, it would be a real stretch from the way courts have read into congressional silence in the past.
Can I follow on that? So there's a huge debate in foreign relations law circles about the extent to which customary international law binds the states, right? Would bind the states under the supremacy clause, or bind the states in many other ways, and many state right people would say, no, absolutely not. They're separate sovereigns. They can do whatever they want, right? And certainly there's no constitutional effect to it. They're as free to violate it as the federal government is. And Justice Scalia effectively says that in his concurring opinion in Sosa at the end, where he's like, if customary international law prohibits the death penalty, well, so be it. States can go ahead and ignore that. It's a little weird after that. It would be weird for Scalia to turn around and say, but states are certainly limited by customary international law rules on jurisdiction to prescribe, right? And here, the rules on jurisdiction to prescribe don't even make that many inroads in extraterritoriality. You almost have to get to comity and say, and so if you don't want to bind Texas by international law rules on jurisdiction to prescribe, you're going to bind them to international comity, which is an even weaker thing. It seems to me that the folks who are sort of like Scalia, who are most opposed to extraterritorial securities regulation, also tend to be the most jealous of state prerogatives to act in the international area. So if you're going to see something, it's going to have to be something that comes through express preemption by Congress.
Yeah, I mean, I absolutely agree with that, and I think one of the problems we're dealing with here is that the state law at issue is just so vast, and it deals with areas of traditional state as opposed to federal concern, or state common law is something we've always thought of as something that can go on unaffected by what the federal government does. So it would really be a revolution, in particularly this court's approach to treat it any other way. I mean, particularly given that we're not talking about express violation of international norms. We really are just talking about comity, and sometimes we're not even talking about things that I think rise to the level of comity as it's been practiced with respect to federal law, but really just an issue of of intent. I think the presumption against territoriality maybe has some sort of implicit comedy dimension, but it's not. Its primary focus isn't comedy per se.
Sir.
Yeah, this is one of the reasons why I think Congress has actually been better than the Supreme Court on a lot of this stuff. When you look at what Congress has done in the areas of jurisdiction lately, really after since some of the boycott stuff in the early 1980s, they have at the very least acknowledged the fact that the United States has obligations under international law, even if they have the power to violate their power. What the court has been doing is saying that Congress has the power, meaning the power and the rightful authority to violate international law. And that's really a very different proposition. To me, one of the worst cases in ages was the Medellin case, because what that said was that we will presume that the United States will violate international law. And so I do think that basically going through Congress towards perhaps a preemption approach, maybe I don't know.
This question of comedy then runs as a thread through both your presentations, Marco. I want to come back to you because you mentioned, or at least the reference to the potential for relief for investors in another jurisdiction would, in the ordinary course, perhaps satisfy. Mm-hmm. Do you think that's a practical matter in terms of what you understand by way of again, I go back to the U.S. domestic political dimension of it, and in particular with states?
Well, I think it might, to some extent. I do think in many ways that this issue should be the object, and this is another thing that it's briefly mentioned in the piece, that what is really missing probably is some kind of international agreement on the issue of jurisdiction in securities law. And my sense is that that would require some preconditions, such as a certain degree of protection of investors in the countries that agree to that. But I think that might be a way to address it politically also, in the sense that if a group of countries might agree on one specific principle, and the one I propose is the effect test, then you would clearly have one country that has jurisdiction, and then of course in some places there would be a higher level of protections, and in other a lower level of protection, but it might work. The other thing I can add, and that goes a little bit to what was said just now, is and I don't want to transform this into a global politics issue, but in many ways it's the United States, as the only remaining superpower, has this attitude, this very aggressive attitude in applying extraterritorially some of its laws, and which most other countries resent, as it's shown by the number of amicus briefs that were filed in the Morrison decision against the extraterritorial application. So to some extent, I do think that it might be easier to reach some kind of international agreement or appeasement going in that direction and trying to find one single criteria.
Either questions or comment? That may actually be a very interesting place to end the discussion, and so why don't I turn it back over to Frank for some closing remarks. Thank you both.
I will keep this brief. My task at this stage is to begin by thanking our audience. It's been a long day, obviously. We appreciate your presence. It's sometimes higher, sometimes lower. But I hope you found it interesting. Then my next task is to thank our speakers for some outstanding presentations. Please don't run off, because I've been tasked by our administrative assistant half of our law review. For those who are interested, we will obviously try to do a printed version as well. For those who were enticed by portions you saw, but were unable to see the whole thing, I am told that this has been recorded and will be posted on the web. I always trust what the tech people tell me. Again,